glad you guys made it. The weather was really tempting to not come, I'm sure, for everyone. I'm going to get over here so I can control the slides. All right. Quick disclaimer, we're going to talk about, we do actually, this is the great because we have an attorney and they can tell you attorney things, but we may talk about those, but we're not attorneys or practicing CPAs, so keep that in mind. So I always like to start off with a quote. And this, if you haven't heard of Robert Kiyosaki, I always say it wrong. He is the author of Rich Dad, Poor Dad, a book that we highly recommend. We have some copies if you guys have not read it. We also have some other investing books new this month. So if you want those at the end, you can help yourself. But the primary difference between the rich person and the poor person is how they manage fear. We'll keep that in mind as we talk through this today. So I am Amy Weisbender, and Karin is at the door. But just, I think I know most of you guys in here. But Karin and I started these classes. We were super passionate about educating others on how to invest in real estate. We're both investors, and we've not always done it right. We've got lots of lessons learned to share with you, but we've both made money, which is great. So you can even like do it wrong and make money. So we wanted to pass on our knowledge and bring people in, bring in vendors, bring in people if you want to invest in real estate who can be your team. So we both actually started with Berkshire in 2019 and connected shortly after that. And we were like, we need to teach people and do these courses. So we started about a year and a half ago. Just a high level, we have Karin and Amy's 5 steps to successful real estate investing. We've got brochures on here that you can take home with you if you'd like. But the other thing that we offer, besides this education that we do once a month, we also have a few other things that you guys can take advantage of. We do investor consultations. So if you are, I want to invest, but I really don't know what I want to do. It's a 1-hour free session where Karin and I sit down with you and we ask you silly questions that you're like, why are you asking me this question? And then at the end, we've got a plan for you on what you want to do next. And if there's any things that you need, any hurdles you need to get to overcome before you're ready, we help you with that and we connect you with resources. You need that? You want one of those? But it's a great way to just take all these like thoughts in your head and get them on paper and put a plan to move forward. Because you won't make money if you do nothing. That's a guarantee. The other thing to help you determine whether you can make money is we have an investor analysis sheet. So it's a spreadsheet, and I've got a new version because thanks to Otis, he found a few mistakes in my last one with some data pulling through on a couple of the sheets. But we've got that that we can provide you, and it walks you. You just plug in the data, and it outputs all the different metrics you need to consider as an investor. So that's free as well. And then we also do real estate reviews. So if you've got a property already and you want to know what your equity is in it, we can run those for you, and because maybe you want to use that equity to invest in another property. So we offer those as well. And we've got a sign-up sheet here that you guys can pass around and put your name and phone number. And then if you want any of those, just check them off, and then Karin and I will reach out to you to get that. But Karin said I can't speak very long because this is not my show. We have a wonderful guest tonight. So, but before we get started, we have also a wonderful guest next month. If you want to know how to buy out of your area, there's a lot of things additionally that you should consider when you're investing outside of your area. So we have the very talented Nicole Ruth, who's also an investor herself, will be here presenting next month. So hope to see you guys there. We also have a Facebook group. All these recordings of our videos we post them there. So if you guys want that, you can always join our group. And now I'm going to get over to Kate's slides. And is Karin in here? Is she still outside? Okay.
Hey, did you hear that Nicole Ruth, the awards for lenders just came out? She was number 18 in the country.
Oh, I did see that.
Crazy number.
Yeah, and number 1 in Colorado.
Colorado by a
yeah.
long shot. So the value of just listening to her and how she does lending is amazing.
Yeah, and she can she's super passionate about investing. She started investing, I think, when she was
Young
40s,
age.
50s or something.
She
And
came from a family with absolutely nothing.
yeah, with absolutely nothing. And now she has a great portfolio that she probably doesn't even have to work. So it's never too late to start. That's the message there. What?
When she was in her 40s or 50s.
Yep. Mm-hmm. Yep. You can do it quickly if you want.
She worked 10 years on Wall Street too. She's an interesting lady.
Yeah. Yeah. She's an amazing speaker. I'm going to Toastmasters so I can be more like her. I'll get there someday. But tonight we have the very talented Kate, and she comes from elder law. She's an elder law attorney, and your company is Rocky Mountain
Elder
Elder
law.
Law. So I'm going to pass it over to Kate because she's got amazing things to share with you, and then you guys are going to be able to ask her questions at the end. So,
And can I ask, how do I advance the slides here?
oh yes, so there should just be.
Okay. There we
That
go.
good?
Hi, everybody. As Amy just so kindly said, I'm an elder law attorney. Half of my practice is estate planning. I'm very, very passionate about it. Estate planning is your fortress. It's really, really important to have. If you're 18 or older and do not have a medical power of attorney, I will do one for free. That's how important that is. I do a whole suite of documents, and we'll get to that. But I'm also a hospice chaplain, and I've been a hospital chaplain for years. So my passion for end-of-life planning and getting ducks in a row is deeply, deeply important to me. I just want to give you a little bit of background about me and let you know that I am married. I have a husband. He's a carpenter, a builder. He works for Kelly Trucking in Golden. He's a supervisor and builds all their, he's built a 55,000 square foot horse arena. He's built all their home in Breckenridge and all the kids' homes, the Kellys. And he also builds all the outbuildings at all the earth moving sites. We love to golf. We have a son, Sam. He's now 17, but still plays football. There's my dad. He was a colonel in the Air Force, a bomb squadron commander, did 6 tours. I inherited that golden doodle. That's part of the reason that he's up there. We have a healer. Part of my background is I was in the fashion business for many, many years and worked as a model and then did press and public relations for Chanel and Fendi. One of the things, I grew up in Crested Butte and was a ski racer. And so when I worked as a model, I did a lot of ski clothes. So I did all the Bogner catalogs and a lot of ski pictures. I also, as a weird fact, worked as a double for Lady Diana. And that's actually me, not her. And I did a lot of photo shoots as her and worked as her decoy. Obviously not on that fateful night. But
you've been an overachiever at all, have you?
So those are just some of the things about me, and I just want you to know who I am and what I love and care about and am passionate about. So there's different areas of elder law. It's kind of an umbrella. I often talk about elder law as being family law, only the other direction. So instead of parents fighting over kids or dealing with property divisions that way, I deal with kids often disputing parents and their property. And therein lies the great secret of having an estate plan, because you do not want to leave a mess, particularly if you own real estate, which I'm clear that all of you do. One of the things I do, and the reason, again, an estate plan is so important, is that it's one barrier and fortress against financial exploitation. I do a lot of financial exploitation work. Unfortunately, people steal. They rob from vulnerable elderly people. They rob from perfectly capable people. I deal a lot with vulnerable at-risk adults who are often elderly. I served on the State Board of Human Services for 8 years and developed the legislation we have now in Colorado, which provides for civil and criminal liability if you abuse, neglect, or financially exploit anyone 70 or older, and anyone who's developmentally disabled at any age. Unfortunately, it's rampant. There is an epidemic of taking advantage of folks who have resources. It can be the handyman who sells 4 $30,000 furnaces to the little old lady who has dementia. It can be the neighbor. It can be the son. It can be the grandson. It can be the spouse. I have 2 cases right now where the spouse has basically left their husband or wife, respectively, in a nursing home and absconded with all the assets, leaving them with nothing for their care. So one of the things I'm very passionate about is going after folks who do things like that. So estate planning, why is it so important? Because I deal with the fallout when there isn't one. So that's why I love to do it. I love to get people's ducks in a row. I love to explain why it's so important. A lot of people say, oh, the will or the trust, that's the most important thing in an estate plan. Well, it is, but it's oftentimes what happens to your stuff after you're gone. I'm also very passionate about what happens to you while you're still here and can't make decisions for yourself. And that's where the directions that you leave are so important. And I often call an estate plan a love letter to the people in your family. So what does it consist of? Well, as you can see, I have a lot of documents. I do what I call a suite of documents. The will, of course. In my will, there's 2 trusts. There's a trust for minor takers, can be children or grandchildren. We can decide what age that is. Usually it's 21 and under. Most grandparents that I work with want their grandchildren to get through college debt-free. That's a huge value. And so 21 usually gets them through college. Sometimes we do the trust in tranches. So there'll be a take at any age under health, education, maintenance, and support. There'll be a tranche at 21, a tranche at 25 gets them through graduate school, and then 33, the final distribution, usually when a grandchild is getting married, maybe puts a down payment on a house, that kind of thing. So we don't write fat checks to 18-year-olds. That is a really bad idea. And I see what happens with that too. And usually the money goes pretty fast, particularly if it's not for college. It can go fast with college, but we don't want people buying Lamborghinis. That's a bad idea. Trusts, I do. There's several different types of trusts. You can protect assets with a trust. There's sophisticated tax planning that can be done with trusts. There's trusts that can hold residences. There's trusts. Trusts are an interesting vehicle. They're almost like it can be a business entity. There's irrevocable trusts, meaning once you sock stuff away in those, you can't touch them again. You can get a stream of income, but you're basically shielding that asset. There's revocable or living trusts. Those do not protect you from probate. Those do not, but they have real usefulness. And I think that for investors, they can be particularly useful. Powers of attorney. I touched on the medical power of attorney. If you have a child going to college, if you have a child that turns 18, you cannot get access to their medical information without being their agent under their power of attorney. And that's because of the HIPAA privacy laws. So if something terrible happens, God forbid, you want to be able to call that hospital, wherever your child is in college, and say, I need to have access to this medical information, and you can be denied that legally if you do not have a medical power of attorney. That's why if you don't have one, I will do them. I'm very passionate about that. Financial power of attorney, very different animal, because as long as you can make your medical decisions, you get to make them. So that's what's called a springing power. Financial power of attorney, standing power. As soon as you sign it, your agent, unless you say only upon my incapacity, your agent has the ability to help you with your finances. You can have a corporate third party fiduciary be in that role, or oftentimes it's your spouse. We want to have a fluidity of information. You do not want to be the only person who has access to digital assets. You do not want to be the only person who has access to checking and savings accounts, investment accounts. You do not want to be the only person who can manage and control any type of conceivable property, whether it be real personal property or cash and other kinds of investment accounts. Because God forbid something happens and your spouse needs to negotiate a lease, your spouse needs to take care of a rental property, your spouse needs to take care of your own mortgage, and they're not on the mortgage. That can be a real challenge and put you in foreclosure if you're not careful. So you always want to have a financial power of attorney in place and a transparency with at least one other person. And if there's no one you can trust, including your spouse, then I recommend a third party bonded, insured fiduciary who knows what you own, knows how to access it. So if anything happens to you and you can't make those decisions, there's someone who can and knows and keeps your best interests at heart.
Yeah, and I would say, so most, when investors come, part of our investor consultation, we highlight what the why is of why do they want to invest in real estate. And a majority of them say because they want to have some money in their retirement and or they want to pass on generational wealth. That's the top answers we usually get for that. But again, like, so I run all of our investment properties. I have property managers, but I'm running them. This is a good point because if I don't think my husband even knows who my property managers are, and that's a problem, right? Because if my goal as an investor is to have money in retirement and pass it on to our kids, and I don't have that set up, if something happens, right?
Yes. And just know also that powers of attorney expire when you expire. So they're only enforceable while you're alive. Powers of attorney for finances and medical end when you die. And that's when the will and a testamentary trust come to life. So what is a last wishes declaration? That's what's called a living will or advance directive. You really need to have one of those. That basically dictates what kind of care you want in certain types of situations. It's very important to have because your agent under your medical power of attorney is going to have directions to make the most difficult decisions they'll ever have to make. You've made them for you. You've made them already.
So I know a lot of people will have those documents. But my question to you is, what have you done for the best tools as a digital tool, for example, or access and leverage those at crises time?
Well, my firm provides a service called DocuBank, and we provide it for 5 years free of charge. It's a service that basically allows hospitals, medical facilities, emergency responders to access your medical power of attorney and your living will electronically. And you carry a card, so you don't have to carry your medical power of attorney with you. You carry a card and they scan it and they can have access to those two documents. It's an incredible service. It's been used to great effect. As someone who worked as a hospital chaplain, I can assure you how important it is that they have ready access to those documents.
Yeah, agreed 100%. But I've had a lot of clients over the years who, in those crisis situations, for that very reason, have not had access to it. Bad things have happened.
Yes. And so that's why we provide DocuBank. It's a really important service.
Can you put any documents in there?
It's basically for medical emergency
Okay.
documents, but that's again why you have to have the tough conversations with your family about where your other documents are, how to access them. We can talk about originals, where they should be kept and how accessible they should be. Um, I'm not a huge fan of safe deposit boxes, but when you're young, I think it's fine. It's just that someone else should know where to find the key. There should be tough conversations. An estate plan is not just it's a love letter that you share. But again, in terms of your financial power of attorney, whom do you trust? And that's why a lot of times with trusts, trustees, agents under financial powers of attorney, I use third-party fiduciaries because they're neutrals. They keep the family out of it. Nobody needs to know what you own and what it's worth if that's a concern, and what kind of income it's producing, but you have assistance at the ready. I do a dementia document. I don't know anyone who does. Dementia is a huge concern for people. A lot of our lives are touched by people with dementia. This basically dictates what kind of treatment you want in mild, moderate, and severe dementia. And oftentimes that's a moving target. Dementia itself is a moving target, but the levels of care you want in those situations are really important. HIPAA release, I think, is self-explanatory. We definitely want at least one person and a backup to have access to your medical information. And there's a HIPAA release built into my financial power of attorney because if the medical bills come in, we want that person who's paying your medical bills to have access to those medical records. As you know, hospitals can make gross errors in terms of billing. They're all over the news all the time. And we want to make sure that whomever's paying those bills has access to those records. Declaration of guardian of adult. Hopefully, because you have a medical power of attorney, you're not going to need a guardian appointed, but there are disputes about care. We've had a conversation already today about the care of an elderly at-risk person. A guardian may need to be appointed. It's really important to nominate that guardian because your nomination will rule the day in court. And finally, a declaration of guardian of minor children. You do not want it to be a free-for-all if something happens to you with your minor children. You want to designate someone who will care for those children and raise those children. It is not something you want to leave up to chance. That is a court battle waiting to happen, and it can get very ugly. So if you want it to be your parent, you need to name that parent. If you want it to be a sister or a brother, or you definitely want to exclude a brother or a sister, you need to make sure you have this document in place. Anyone with children 18 and younger needs to have this. So that's estate planning, not just a will, not just a trust. It's very comprehensive. We talked about wills, and I know that I mentioned that they are what happens when you die. They're the stuff. There's a specific structure to a will. The first tranche that comes out of a will is the personal property. So that's the stuff you can touch. But some people collect things. They collect things like guns or Navajo rugs or Steinway pianos. We want to be very specific and intentional about where we leave our things and not just in one big pot. It may be that you have no children who play that Steinway, but you have a nephew. I had clients who had a nephew who played, so they wanted to leave that. Otherwise, it goes into the big overall pot, and that's what you always wanted, was for that niece to have the grandmother's engagement ring. And suddenly it's being appraised and sold and not kept in the family. So we want to make sure that those items, the things you can touch, they deserve a degree of attention as well in your plan. What kind of sifts out from there is anything with a beneficiary. So there's really creative ways to title assets that not only keep them out of probate, and just as an aside, probate in Colorado is efficient, it's affordable, it's not something that necessarily has to be avoided, but we do want to lift out
Does everyone know
assets.
what probate is in here? Or do we want to define that?
We're getting to that slide,
Okay,
but
gotcha.
in
Okay.
terms of probate, that's when a will is submitted to a court and the property that's passed under that will is distributed to the heirs at law. So who's named in the will? There can be in the state of Colorado, there's obviously multitudes of counties. Some are better than others in terms of the administration of a probate, in terms of its swiftness. Jefferson County is wonderful. Denver County, not so wonderful. It's no diss to the judges.
So, and I would say just from personal experience, other states are not very great when it comes to probate. So especially if you got rental properties in other states, you need to understand this because you could lose significantly your goal of your investing due to
Well,
probate.
if you have properties in another state, that's a whole conversation that we deal with in our intake process because we do want to place those in a trust or an LLC. We don't want to administer two probates in two different states. We want to have one probate and have those assets automatically be titled as Colorado entities or in a Colorado trust. We want to be very careful about that because I practiced in New York. New York is like Illinois, Florida, Kansas. I mean, California's the worst. You want to have everything in a trust, including your socks. I mean, you want to have everything in a trust. And we can do that here too. But again, Colorado's very efficient, and it's okay if you have just a small estate affidavit or you don't have to do everything to avoid probate. But a lot of my clients are very, very concerned with keeping everything out of probate, and we can certainly do that. It's a pretty efficient schedule on a trust to do that. But wills often leave things into trust. Like I said, there's two trusts under my will, the one for minors, and then there's one for disabled people at any age. And why do we have that second trust? We have that second trust because people get disability benefits. And if they get a windfall, no more disability benefits. So the federal government allows a whole schedule of what things are allowed you can pull from a trust, like family vacations, modifications to a house, vans, computers, all kinds of things that do not interrupt that flow of benefits. The reason we don't want to do that is because with a windfall, you're knocked off your disability and it's very difficult to get back on. It's a real challenge. So we want to have those two trusts. But a lot of my wills have what I call an Article 4 trust, and that's what's called just a general testamentary trust. And that's created upon your death. It's a trust that is a general trust and can be tailored in a multitude of ways with a multitude tiered structure of beneficiaries. And I think this is where we can really be creative with how you want to leave your property or properties. And there can be various tax strategies. I don't have an LLM in tax. I'm not a tax professional, but I certainly work in tandem with them. Right now I'm creating a life insurance trust, primary residence trust, and trust that automatically fails. That's a whole other conversation, but it's all to protect folks from the ambit of estate tax. Now, right now, as probably many of you know, the federal exemption is 11 million an individual, 22 million a couple. That is set to sunset in 2025. So we're going to go back to Bush senior levels. I don't think our Congress is going to allow that, but as we know, stranger things have happened. So we don't cross our fingers on this one, we plan. One of the things that we have to plan for is to drop down to 6 million in an individual, 12 million a couple. That's a significant drop. And anything over that you own at the time of your death will be taxed 40%. So there has to be a lot of strategies done, including gifting and other things, so that we don't have estate tax liability. I am not talking about tax evasion. I am talking about avoiding taxable events. Now that may be splitting hairs to some of you, but I have to do that, that proviso. So I really feel strongly that with assets that increase in value over time, and that's what we're talking about here is real estate, we have to be very conscious of this sunset provision, because it doesn't take too many properties in Colorado to get over 6 million. It just doesn't. And we really want to be careful. Valuations, I know that we're in a strange market right now, but Colorado remains really healthy overall. And we just have to be conscious of that in our planning. So I was talking about doing these other kinds of trusts. There's life insurance, there's these residence trusts, there's really creative ways to move things out of your taxable estate. And that's what we want to do with a good estate plan, particularly with folks who are investors. We want to create, again, that fortress. It's not just a fortress against any kind of exploitation, it's a fortress against any kind of estate tax liability. And part of that, I tell people one strategy is spending it and giving it away. Other strategies are creative use of trusts. But there has to be, in my view, a combination, because in giving it away, if you're going to reach that threshold and you're going to be taxed, we want to do some creative gifting strategies, because we're either going to do that or we're going to give it to the IRS. And most people I know would rather not give it to the IRS. So there's multiple, it's almost like a puzzle, a good estate plan. There's several pieces. There's the pieces that happen while you're alive. There's the pieces that happen when you pass. And then there's the pieces that have to do with how do we title and hold properties so that they either pass automatically to beneficiaries, that they either are titled creatively if they're real property, with beneficiary deeds, those kinds of things that pass automatically upon your death. So you have full control, you exercise full control while you're alive, but once you pass, they do not pass inside your estate. So we can do creative things to allow for trusts to work for you and work for what you've worked all your life for to save. And like you said, that primary goal of intergenerational wealth that people are so concerned about. So we want to protect things for your grandchildren. You just had a baby, so their children. We want to leave something for your child's children. We talked about living wills, advance directives, how important that is, the powers of attorney. I've kind of just given you the broad overview. Does anyone have any questions about powers of attorney and how they work? The medical power, again, is a springing power. As long as you can make your medical decisions, you make them. The financial power, again, is working in tandem with another person or corporate fiduciary. And I can't emphasize enough, you have to share your digital assets. You have to make available to at least one other person. I don't care if it's a password protected Excel spreadsheet. I don't care if it's some kind of smart vault, but your passwords must be accessible to someone else on all your financial accounts.
So powers of attorney are filed with the courts,
They're private.
so we have to know where they keep
Yes. That's where those conversations come in. Most people don't like to talk about it. You talk to someone 70 and older, they do not want to talk about their assets or an estate plan. I have to really work hard at getting people to understand they need an estate plan at any age. But particularly as they get older, it's critical to have a person that you trust who knows where to find everything.
And if they say oh, I think I have one, and I can't tell you whose name it is or where it is, just have a new one made.
Then you have a new one made. Yeah. And once you do a new power of attorney, just like with a will, it obviates the previous ones. They go poof. That's not to say there's never dueling wills. I do will contests. That's usually the situation with the deathbed will. Someone with dementia, and they put a will in front of grandma that leaves everything to them, and the undue influence is relatively clear. It's not always the case, though, that it is. There can be a later will, but again, if there's a diagnosis of dementia before that later will was signed, that's a big problem. One of the things I don't do is remote will signings or remote notaries. I just think there's too much room for undue influence, and you never know who's in the room with a video camera. I mean, I'm on camera right now, but the person watching me right now does not know that you're in the room. And that's a big problem for me. So I like to have 2 heartbeats, 2 witnesses. If you come to my office, I have a staff that's there every day. I believe in having real living live witnesses, real living live notary, and I want to know who's in the room when they're executing documents. It's very, very important. Last wishes declaration. This is something people really don't want to talk about, but it's very important to let your family know if you want to be buried or cremated and where you want your ashes. It's a gift that you give them. As a chaplain, I've seen so many families already in the throes of grief trying to figure out what grandma or grandpa wanted. And there are fights. Unfortunately, I've seen fist fights over dead bodies, and I'm not exaggerating about this very issue. The dementia document we covered. If anyone has any questions as we go, the HIPAA release, obviously incredibly important. We want to make sure, again, it's that difficult conversation, but it's saying, if something happens to me, I want you to be the point person.
Was it HIPAA release strictly giving you access to their medical information as opposed to medical power of attorney?
Well, it's basically, I have in many of my documents, like the will, built-in trusts, it's the same with the medical durable power of attorney and the HIPAA release. The medical durable power of attorney has HIPAA language all over it.
Well, that's what I mean, so they sort of overlap in a way.
They overlap. It's a belts and suspenders type of approach, but I err on the side of caution,
Yeah.
because if there isn't, if a hospital becomes difficult and they are known to be, or a nursing home, you have, yeah, you're covered. We talked about the guardian of an adult or of minor children. And then we touched on probate. But again, probate in Colorado is not something to be feared. That said, we work to make sure that beneficiaries, that it passes according to the terms of the will. Some people disinherit people, and that can be an issue in probate because there's challenges. They don't like to be disinherited, or someone's gotten advances on their inheritance improperly or properly, and that's reflected in the structure of the will. So there can be disputes, and unfortunately, that's where probate litigation comes in. Disgruntled heirs. The biggest source of probate litigation is when there's no estate plan. So if you want to avoid costly legal fights, costly legal fees, you plan, because courts are loath to challenge a good plan, and they don't take kindly to people challenging them. They say this is what the decedent wanted, and there's what's called in Colorado a dead man statute. And that means no one can testify to what the decedent said he wanted or she wanted. The documents speak for themselves. But guess what happens when there's no documents? The decedent can't speak. It can be a free-for-all. And when the assets get larger, the fights get more bitter. It's just human beings. And finally, just touching on guardianships, conservatorships, if you don't have powers of attorney, a financial or medical power of attorney, and you become incapacitated and unable to make your own medical decisions, and you have no one named as an agent, you become unable to make your financial decisions, and you have no one named as a financial power of attorney, you have to hire someone like me to go to court and get a guardian and conservator. That's a far more expensive proposition. Going to court for anything is expensive. And a guardian is someone appointed by the court, sometimes a family member, sometimes a third-party professional, who handles the medical decision-making and well-being of what's called a ward. In a conservatorship, it's called a protected person, and the conservator is the one who handles the money. So oftentimes the guardian and conservator are the same person, but sometimes they're separated out. Sometimes in families, like today, I got a case where two brothers are going to be co-guardians and co-conservators over their mother. So it can be a dual role. And sometimes that's a good thing because there's checks and balances. Sometimes it's a bad thing because there's checks and balances. And can be strong disagreements about care or financial decision making. What's best for mom.